Good evening, everyone. Welcome to today's webinar, Institutionalizing Mediation, a blueprint for effective dispute resolution. My name is Ayn Zehra, and I will be your host for this session. We are delighted to have you join us as we explore the framework and strategies essential for embedding mediation into our dispute resolution systems. Now, before we begin, I'd like to cover a few housekeeping points. Firstly, please ensure your microphones remain muted throughout the session to minimize background noise. We encourage you to keep your cameras on to foster a more interactive and engaging environment. Thirdly, feel free to drop your questions or comments in the chat box at any time. Now, it is my distinct pleasure to introduce our esteemed speaker, Mr. AJ Jawad. Mr. Jawad is a seasoned advocate with 35 years of experience in the legal field and a distinguished senior mediator and trainer with over 18 years of expertise in civil, commercial, international, and matrimonial mediations. He currently serves as the Registrar of the International Arbitration and Mediation Center in Hyderabad. Throughout his career, Mr. Jawad has been a passionate promoter of mediation in India, contributing significantly to its growth and development. We are honored to have him with us today to share his insights on institutionalizing mediation. Please join me in welcoming Mr. AJ Jawad. Mr. Jawad, the floor is all yours.
Thank you so much, Ayin, and thank you, Mediate Guru, for this opportunity. And I'm really surprised that on a Sunday evening, there are so many people who have gathered here. So good evening to all of you. Ayin, are we going to have this in a question answer form, or how do you plan to go about it?
Sir, we planned a question answer form once you give a bit of your presentation, and then we'll be having question answer session.
All right. So basically the topic today is institutionalizing mediation, how important it is. The analogy I would like to give here, though, mediation and arbitration are two completely different processes, but both, giving a lot of party autonomy in terms of choosing the arbitrator, in terms of, deciding the procedure. So when you compare both these, you realize that how important institutionalization of these processes is. Because today there is a crying need in India for institutionalizing both arbitration as well as mediation. In the absence of institutionalization, what happens is the processes become ad hoc. And, there is no proper, parties don't get enough confidence in the process itself, simply because they don't know who's regulating this and what is happening in terms of what would happen if, you reach a settlement agreement. So there is a lot of confusion that prevails over there. And not only that, in terms of even the quality of the mediators, the quality of the service providers, that takes a beating, because if it is ad hoc, there's no way that the quality of the service that is being offered can be assured. Now, when you institutionalize a process like mediation, what would happen definitely is that the institutions will take care to empanel only those people who are well skilled, well trained, and who can really do justice to the job of mediating a conflict. Because mediation is not a process that can be treated as a simple dispute resolution process like any adjudicatory process. In one of the classes that I have been taking, one of the participants came out with a very good term. He said that we are delegalizing dispute resolution, and that is what is happening in mediation, because we are taking it out of the complexities and the intricacies and the hair splitting exercise that normally legal procedures undertake. So when you look at litigation, for instance, you have the procedures are so complex and complicated that the common man doesn't understand it. I remember reading a joke sometime back where one friend tells to the other that, I had this dispute with my neighbor and I went to a lawyer. So the friend says that, why did you go to a lawyer? After all, everything is there in the book. So the friend replies, but the lawyer knows which page it is on. So, to basically people get confounded with the whole complexity of that, right? But mediation is a different process. Mediation focuses more on the human element of the conflict. And because, whether you like it or not, lawyers being the biggest stakeholders in dispute resolution, a majority of the lawyers are becoming mediators today. So they are taking it as a part of their professional competence to be able to mediate or even assist clients in mediation. And this is where, a lot of, competency is required, because lawyers being trained in an adversarial method of dispute resolution, because see, the way we look at disputes today is in binaries of right and wrong, and in the second binary that we follow is reward and punishment. But disputes and conflicts are more complex than that. You cannot just put them in these binaries or put them in these silos of rights and wrongs and try to adjudicate them, because it depends on how people perceive the whole issue, what is their point of view about the dispute, how they are looking at the conflict, how they are looking at the other side. So keeping in mind all this, you need a different mindset to be able to do mediations. And it requires a different kind of specialized training to be able to mediate effectively. Now, what we see very often is that courts appoint people who are untrained in mediation, who have no mediation experience or who don't understand how the mediation process works, because the general perception is mediation is, after all, you make the people sit and ask them, how do you want to resolve this, and then tell them a few ideas on how they can settle it. So that's how people look at mediation. So that is where the training is required, and that's where the competency is required. Now, by institutionalizing, what we are doing is we are ensuring, we are assuring people that what we have on our panel are competent mediators who have been trained to do the process effectively with the objective of the addressing the human element of the conflict and basically delegalizing the dispute resolution itself. So we are not going to get into the complexities of who's right and who's wrong, but rather we are going to be discussing about how to solve the problem. So from a problem inflaming approach, we are going to be taking a problem solving approach. And there the training becomes very important. Now, if you look at the Mediation Act itself provides for two kinds of institutions to be established. Now, I'm not talking about the Mediation Council of India. That's the overarching body that is going to be supervising the entire mediation, the institutions and the service providers. But it contemplates two kinds of institutions. One are the mediation service providers, and the other are the mediation institutes. So the mediation service providers are those institutions like we have IAMC, for instance, where we have a panel of mediators, and whenever parties come to us with a conflict or with a dispute, we appoint mediators who are either trained by us or trained by institutions who are recognized by us. So, and we are able to monitor the process also. And, it's easy for the parties to get back to us if there is a problem with the mediator, or if there is any problem with the process, or the parties feel that the mediator is being biased. They can always come back to us, and we change the mediator immediately. Now, in my experience with the court annex mediation program, what I've seen is, though the Mediation Act contemplates the court annex mediation itself as a mediation service provider, one of the challenges has been the feedback from the parties. Because very often, sometimes, what happens, there are serious complaints against mediators, but because we don't have a proper mechanism there to address those concerns of the parties, because, courts are already overburdened with work, and they are doing the mediation part of it. They are undertaking, they are offering the service to parties where there is a possibility of finding a settlement. So we can't expect the courts to keep looking into these complaints and taking action. So it becomes a little bit complicated there. And parties are left with no other option but to either withdraw from the mediation or to go ahead with it and without knowing what to do, or maybe face the consequences. Now, institutionalization will ensure that there is accountability of the mediators who are rendering the service of mediation. So, what will happen is the institutions will be able to monitor the performance of the mediators, get feedback from the parties. Not only that, see, just a 40-hour training is not enough for mediators, because I always, whenever I conduct a 40-hour training program, I tell the trainees that this is only the beginning, because you have just taken one foot forward, and there's a whole journey ahead of you, and you have to undergo a continuous professional development where mediation is concerned, because that is applicable in every profession. You have to undergo the continuous professional development. Perhaps only we lawyers don't think the need of that, but all professions undergo that. But and it is especially required for mediators. For example, even the training curriculum, you have to keep upgrading it. There are so many changes that are happening. There is so much of research that is going on into negotiation processes, into neuroscience, into so many things that are happening all over the world. The whole with the kind of technology that's coming up. So how do you utilize technology to do online dispute resolution? Now, all these things, you need a continuous professional development, and that's something that institutions can do for their members. So after taking charge of IAMC, I have been implementing all these protocols in place. It's still in the process because I'm only 1 month old here. But what we are trying to do is we are trying to bring about this, getting undertaking from our panel mediators that they will undergo at least 2 continuous professional development programs that we will be organizing. So in that way, we are able to ensure the quality of the service that is being offered. And therefore, I feel that the institutionalization of mediation would be very important. Now, if you look at arbitration, what has happened to arbitration? Because of the fact that we don't have good arbitration institutions, today the problem is the process has become so complex. And starting from the appointment of the arbitrator. Now, the difference is that if you have institutional arbitration, which means that your contract says that if there is a dispute, we will go to so and so institution. Now, what you do is, if there is a dispute, you go to the institution, and the institution writes to the other side, asks for the other side's consent for the appointment of arbitrator. Now, even if the other side does not agree, the institution appoints the arbitrator. So you don't have to go to the court by way of Section 11 and wait for eternity for even the appointment of the arbitrator. Now, the other thing is, what happens is institutions, have their own rules, and they frame, the time. They fix the time frame within which an arbitration should be completed. They have their own fee rules. So all these things make it a much more, viable option for parties to opt for arbitration. Now, what we are not having today in India is credible institutions that would be able to offer these services. Now, mediation and arbitration go hand in hand simply because both processes empower the parties to choose how they want to resolve the dispute. So, if I have a contract, now I can have a clause in my contract that says that I would like to first go for mediation, and if the mediation doesn't work, I can go for arbitration. Now, if you have institutionalized mediation and arbitration, the advantage there is you go to the institution appoints the mediator, fixes a time frame for the mediator to complete the mediation. Now, once the mediation is over, there are 3 things possible. One is your dispute might get resolved. You have a settlement agreement. Now, the act says that it is as effective as a decree of the court. So you have something which is executable. If supposing you are partially able to reach an agreement on some of the issues and some issues remain unresolved, then you have an agreement for those issues that have been resolved, and for the remaining issues, you can go for the arbitration. If it is not settled, then what the institution does is it straight away appoints an arbitrator. So the moment you get a report from the mediator saying that the matter has not been settled, the arbitration process starts. So you appoint an arbitrator, and the arbitrator now goes into the issue and passes an award, adjudicates the dispute. So this is the advantage, because one, it is very expeditious, it is cost effective. The third advantage is, see, in ad hoc arbitration, what happens? You go to the court, invariably, either a retired judge is appointed or a senior lawyer or somebody is appointed. Now, in institutional arbitration or mediation, one of the advantages would be that people with the technical expertise in the subject matter can also be appointed. And institutions will ensure that, see, for example, in our institution, in IAMC, we are making it very clear that even arbitrators will have to undergo the training. And if you look at the Singapore International Arbitration Center, every award that is passed by the arbitrators undergoes a scrutiny. So the scrutiny of the awards becomes a very important step that should be taken to avoid any challenges to the award. So once somebody scrutinizes, the institution scrutinizes the award through experts, what happens is whatever corrections have to be made, whatever mistakes that are there in the award, if there is some decision which is not proper, all these can be checked and you can have an award that would be enforceable. So the scope for challenging the award becomes substantially narrow if you institutionalize it. So that is where I think we should all start promoting institutions and start supporting institutions and try to ensure that even the institution, because see, one of the challenges in our country is we will set up institutions but without the credibility, without the integrity, without the competence. Now that is something that we have to be very careful about, because we have to ensure that those whom we empanel as mediators or arbitrators are of the highest quality, and they have the best skills, and there is proper monitoring, there is proper accountability. So that would be the only way where India can make a mark in the international market. By refusing to do that, what we are doing is we are giving away the market to other countries, to other institutions that are able to show the kind of competence and the professionalism that is required. So I'll just stop there. I'm sorry, I think I spoke too much.
All right. Thank you so much, sir. Um, Thank you for your insightful presentation on institutionalizing mediation. We will now be transitioning to the question and answer segment, and I encourage all the participants to submit their questions or comments through the chat box. We will address as many as time permits. So, also, sir, we have a few questions for you ready. So,
Yeah, sure.
firstly, the question was, should mediated settlement agreements be subject to judicial review to prevent coercion or procedural unfairness, or would such a requirement undermine the finality and efficiency of mediation?
See, first let us understand one thing.
Yes, sir.
Mediation is a voluntary process. Okay,
Hmm.
parties are free to withdraw from the process at any point of time. So the concern about coercion very rarely arises, except where parties are so ill-informed, or where perhaps the mediator is some very powerful person who is able to push through something down the throats of the parties. Okay. But the fact is that parties can always withdraw from the mediation, and they do not have to accept an agreement that is unfair to them. Okay, number one. Number two is the by subjecting mediated settlement agreements to judicial review, we are doing what the 1940 Act did to arbitration. See, the 1940 Act was repealed, and 1996 Act came into force simply because in the 1940 Act, every arbitral award had to be made rule of the court. So you had to go to the court and make it a rule of the court. Now, to avoid that possibility, to keep judicial intervention at the minimum, the Arbitration Act of 1996 was brought. Now, even in the 1996 Act, it was found that the judicial intervention keeps on increasing. Okay, because in one way or the other. Now, here that's the problem with our culture, simply because we don't believe in the autonomy of people to decide for themselves. See, whether it is mediation or arbitration, the whole idea behind the concept of mediation and arbitration is to give the parties an option to go out of the court system and to find solutions for themselves by either going in for mediation or by going in for arbitration, where they appoint their own person, a person of their choice, to decide the dispute and agree that whatever that person decides, we will abide by that. So that is the objective with which these two processes continue. Then there's no point in again going back to the court. See, there's always the option. If it is a coercive agreement, the party can always, even the Mediation Act provides certain grounds for setting aside settlement agreement. Right? You can always go for that. But to subject every agreement which you reach to judicial review would be, absolutely nullifying the very purpose of mediation. That what is the point? I mean, the very idea of expeditiously, completing the process will be completely lost. So whether it's an arbitral award or whether it is a mediated settlement agreement, you're not happy with it. If you feel that it is something which is unfair, you can always have it set aside by pointing out to the court that these are the reasons why I don't think I should be bound by this agreement, right? But we will be doing a great disservice by saying that every mediated settlement agreement should undergo judicial review. It would really be, I'm sorry to use a strong word, it would be really absurd to do that.
All right. All right. Okay. Thank you so much, sir. The next question we have is, what course of action should be taken if one party is dissatisfied with the first appointed mediator and the other party is dissatisfied with the next appointed mediator?
You appoint a third mediator.
All right.
Right?
Surely.
Yeah.
The other question we
The
have
other
is
thing,
that.
that is where the institutional mediation becomes very important, because what happens when you go to an institution, you have a panel of mediators, and parties have the option of agreeing together to choose a mediator or leave it to the institution to appoint the mediator. Now, unless and until now, you cannot say that I don't like the mediator simply because I don't like the glasses that the mediator is wearing, or the sari that the mediator is wearing, or the color of the lipstick that the mediator is wearing, or the mediator is dark complexion. You can't say that, right? Unless and until you are able to show that there is something that the mediator is doing that shows pronounced bias, or the mediator's neutrality is compromised in some way, or the mediator is not treating the parties fairly. Unless you're able to show that, there is no question of changing the mediator. So at your whims and fancies, you can't keep changing the mediator because it doesn't help you in any way, right? But what happens once an institution appoints the mediator? Most of the time, what would happen would be that the appointment would be a very reasonable and fair one, simply because the institution has nothing to do with the dispute itself or with the parties themselves, right? So that way, what will happen is there will be, no occasion for the parties to complain about the mediator unless there is, gross misconduct on the part of the mediator. Yeah.
Okay, thank you so much, sir, for that. The other question we have is, how does one institutionalize mediation without commercializing it?
What is wrong with commercializing it? You have to make it professional, right? Our legal profession is a profession. You charge fees for that, and arbitrators charge fees. Judges get paid salaries. So why should the poor mediator not get paid for whatever the service that is being rendered? How long are we going to call it as a noble profession and an honorable profession? What can be more divine than rendering justice? Judges do get their salaries and perks and benefits. Arbitrators charge a fee. So why not the mediators? And why not the institutions that provide the service? After all, it is a profession. And if you really want to have good quality, then you need to pay for it. Correct? So there is nothing wrong in, let us not treat commercialization as an evil or a sinful thing to do. It's not. Okay, it ensures quality, actually. Because if you go to Jawad as a lawyer and you go to either Mukul Rohatgi or Harish Salve as a lawyer, the fees charged is different, right? I mean, that's because of the quality of service that you get from those people, right? So therefore, you have to, if you want a good quality of service, you need to pay for it. Of course, compared to what you will be paying for conducting a case in the court or even doing an arbitration, mediation would be substantially lesser, because you won't be spending as much time, and the kind of delays that take place in arbitration and litigation would not be there in mediation, because you are in control of everything as a party to the mediation. So when parties, for example, come and ask me, how long is it going to take to complete this mediation? I tell them that I don't know, you tell me, because you're the ones who are going to decide. I'm not going to decide, right? So the quicker you settle, the faster you get the remedy, right? So therefore, there's nothing sinful about the commercialization of mediation, because unless you have good trained professionals who are going to get something out of it, you're not going to have good quality of dispute or the service itself. Okay.
Okay, thank you, sir. We have another question. Can arbitral award be challenged in court? If yes, on what grounds?
Arbitral award.
Yes, sir.
I think that you'll have to refer to the Arbitration and Conciliation Act, Section 34, which gives the grounds for challenging an arbitral award. So the scope is very narrow, but nevertheless, you can challenge an award, provided you're able to make out the grounds that are stipulated there. So either you have not received proper notice, or no proper opportunity has been given to you, or the award is against public policy. I think there are various grounds that are there. You can have a look at Section 34 of the arbitration laws.
All right, sir. The next question is, how can institutions establish and maintain standards for mediator accreditation, and what are the benefits and challenges of doing so?
See, how can you, because you need to have proper training standards. Okay.
Hmm.
So there are some training standards that have been evolved globally. There are some good practices that are, implemented for conducting the training program. And most important is the trainees should understand the distinction between adversarial dispute resolution and collaborative dispute resolution. And they should understand that they need to, be neutral over there, be impartial with the parties, and be able to refrain from judging or advising the parties, and be able to facilitate the process in such a way that the outcome is that of the parties, that's something that the parties agree to. Now, this becomes a very important part of the mediator training, because and also mediator competency. Why this is important is simply because there is an element of finality to a mediated settlement agreement. Simply because it is the parties' agreement, it is not something that has been imposed upon them by a judge or by an arbitrator. So, if that has to happen, parties have to enter into the agreement with full knowledge of all the pros and cons, and after understanding that this is the best thing that could happen to them. Okay. So we have to move the parties from their positions to their interests and help them to understand what is important for them, and then guide them towards reaching a settlement that is acceptable to them, something that they can live with. Now, for this, it's very important to have very good training, first of all, a proper curriculum for the training, proper material for the training, qualified trainers who can really impart that kind of training, who really believe in mediation, and who have got the expertise and the professional experience in conducting mediations. So this becomes very important. And then the accreditation standards should be such that they should make sure that the best people come. See, today, for example, many institutions conduct mediation but don't do an assessment of the trainees after they complete the training. Now, it's very important to do the assessment to find out whether they have imbibed the basic essential concepts and principles of mediation. You may not become a very good, competent mediator immediately after a 40-hour training. But what is important is, at least if you have understood the basic concepts of mediation and what is your role as a mediator, what kind of skills you need as a mediator. Those skills will gradually develop as you keep doing, and as you keep practicing, maybe assisting senior mediators in conducting mediations, undergoing continuous professional development, attending refresher programs. With all this, you can improve your skills. But you need to have those basic skills essential to act as a mediator. You need to have that aptitude, the attitude, all these things become very important. So mediation training program is not just about telling people, oh, these are the communication skills, these are the negotiation skills, these are the stages of mediation. You need to impress upon them the importance of imbibing those skills on how do you communicate without judging, how do you empathetically listen to parties, how do you guide the parties, how do you ask questions to the parties. Now, all these things become very essential and integral to the mediation training itself. So unless and until the trainers are well equipped to deliver that kind of training, the problem would be that we will have half-baked mediators who don't understand the process fully. Okay. So it takes a long time for people to come out of their, you see, the whole mindset transformation that needs to happen for a mediator needs to happen in those 40 hours. Now, the skill can develop later, once they understand the conceptual framework of mediation and they believe in it, then the transformation keeps happening gradually. Okay. So as you keep practicing, you learn more and more skills. You really understand how to deal with difficult situations, all that. So there the training standards and the accreditation standards become extremely important. Also keeping in mind, because you cannot blindly adopt some other country's training manual and say that, oh, we have a training program that is approved by so and so. You need to also keep in mind the cultural imperatives of our country and our cultural aspects. So how do you integrate all these things and conduct an effective training program becomes a big challenge for institutions. Okay, so they have to do it effectively, otherwise the whole process is going to fail. It's like training a doctor, right? You can't
Yes, sir.
train a half-baked doctor and allow the doctor to perform a surgery, right? So you know what will happen to the patient. So mediator competency becomes very important. Okay, and it's important for those who get trained as mediators to remember that they are starting off on the journey. Okay, and keep what is called as reflective practice. Okay, keep on reflecting on what they have done in each mediation. Keep a notebook, make a note of what did I do right, what could I have done better. So keep trying to improve yourself. Okay, so that becomes very important.
A great example, sir. So one of the participants have a question that how is confidentiality maintained in the mediation process?
See, confidentiality is essentially what is the reason for confidentiality? Let's understand that. See, the reason for confidentiality is that parties are going to be sharing with you information that they may not have shared even with their lawyers. Parties are going to be sharing information with you that nobody else would know except them. Okay. Now, why would they do that? As a mediator, how can you sit there? One of my trainers from Greece said, isn't it audacious on your part to sit there as a neutral third person and expect parties to share their deepest fears and concerns with you? Now, what gives them that courage to do so is the assurance of confidentiality. Okay. Now, this is something that you have to get the parties to agree to and abide by it. Now, how do you do that? Because they may sign an agreement, okay, but how do you ensure that there's no breach of confidentiality? Now, this is where you tell the parties that, look, this is your information. You own this information, okay? So if you own this information, it is for you to safeguard this information. So how do you, if you disclose this information outside, you're going to be compromising your own interests because you don't know how it's going to affect you. So it's for you to safeguard this information because you own it. Now, what about the other person's information? What happens if a party gets some confidential information in a mediation from the other party and tries to misuse it later on? Now, there again, the rules and regulations come into play. Because if the law says that whatever information is exchanged in a mediation process, that is completely confidential. So the court will not accept anything that has come out of a mediation process. So the confidentiality is assured in that sense. The other way of doing it also is that you have private sessions with the parties whenever they want to discuss any confidential information that would prejudice them in some way or that would affect them in the long run. So you can have private sessions to ensure that that information does not, leak out. And you as a mediator have to make sure that you maintain the confidentiality. And unless and until you're absolutely sure that it's not going to hurt the party who's disclosing it, you don't disclose that information. Okay, and with the party's permission. So without the party's permission, you cannot disclose. So these are some of the ways that you can ensure the confidential. Now, one of the challenges that comes is when you're having an online session. Now, you don't know who's sitting in the room, who's, listening to it, or if somebody is making a record of it. Now, when you ask the parties to scan the room with the camera to show that nobody else is there, you can't ask them to keep doing it every 5 minutes because you don't know when they will scan it once and then somebody else will walk into the room. How do you know that nobody is there? Right. So what you do, basically what I do there is I tell the parties that, look, I trust you for this. Okay. And because it's your matter, if you wish to have somebody in the room, please have that person with you and let that person also be bound by the confidentiality. So the only way you can ensure that the other person's information doesn't get misused is by having private sessions with each of the parties where you encourage them to disclose the confidential information. And of course, the law is always there. So you can always, if the party tries to breach the confidentiality, you can always use it. Now, one thing about confidentiality in mediation is both parties can agree to waive off the confidentiality because it's their information, right? They own that information. If both of them agree, then confidentiality can be waived.
Okay, sir. Sir, another participant has a question. What are the key principles and best practices for accrediting mediators, and how do institutions balance quality assurance with accessibility in mediation services?
I think that I have answered already because I said that the
Uh,
institutions will have to
yes.
maintain the highest standards,
Hmm,
engage the best trainers,
hmm,
do a proper assessment of the mediators, keep doing continuous professional development programs, refresher programs for the mediators,
hmm,
for their
hmm,
empaneled mediators, and make sure that the quality is maintained. Also, try to monitor and have proper feedback mechanisms from the parties, where parties can always get back to the institution and give them the feedback about the mediator's performance. So
hmm,
these are the things that and also the fact that if a mediator misconducts himself or herself, the possibility of removal from the empanelment, and also reporting to the mediation council once it gets established. So
hmm,
these are all the mechanisms where you can ensure that there is a quality of service that is rendered. Now,
hmm,
that is where I keep saying that unless you professionalize it, because when you treat it as a profession, then you come up with the best quality. Okay, the best
hmm,
will come forward, and the market will decide for itself who's good and who's bad. So therefore, even the institutions will be held accountable ultimately
hmm,
to the market. So people will know that okay, this institution is good. It has the best mediators, and it follows the best practices, and therefore you engage that institution, you engage that mediator. So that's the way it works.
hmm. Sir, another participant has a very genuine question. Can
Hmm.
a lawyer work only as a mediator? Is
Hmm.
it practical considering the financial remunerations a mediator may receive from a firm?
Yeah, that's a good question. Now we are reaching there. Okay, 10 years or 12 years back, I decided to get in full time into mediation, and I gave up my litigation and started doing mediations. And I have been lucky, I suppose. There has been no looking back for me. I've only been moving forward. But I don't think for everybody that kind of opportunity will come. But one thing I do realize is that over a period of time, there will come a time when we will have exclusive mediation practitioners. So people who will do only mediations and not any other form of practice. That has already happened in many countries. Like for example, in the US itself, the American Bar Association, I'm told, has got two sections: the litigation section and the mediation section. So there are lawyers who practice exclusively on the mediation side as mediators, as lawyers assisting parties in mediation, or what are called as mediation advocates. So they do that. Okay, so there is, once the market grows, once people become more aware, once institutions start establishing themselves, and once the awareness grows, and once we have the best practices in place, and once it becomes completely professionalized, that would be the time when you can be an exclusive mediation practitioner. So the day is not far off. We are all hoping that it will happen even tomorrow, but it will happen, and we are waiting for the act. For some reason, the act is not getting notified. Once the act comes into force, that would be a game changer. The very passing of the act was brought about a huge demand for mediation training, and people wanted to know what is mediation all about. So that is where I think the law is going to play a very significant role in transforming this.
Thank you, sir. Another question is also very interesting. It is, do you think artificial intelligence will have any impact on online mediation?
See, artificial intelligence is going to have an impact on everything. It's going to have an impact on the way we live our lives, the way we understand things, the way even the way our students are going to study, the way professionals are going to do their jobs. So it's definitely going to have an impact on every aspect of our life. And definitely, I mean, even in dispute resolution, AI would play a significant role. It's already doing so. Because if you take the e-commerce platforms like Amazon, Alibaba, eBay, they're already implementing AI tools to resolve disputes. And I'm told that I think eBay started implementing that first, And I'm told that out of 60 million dispute, 1 in 60 million disputes comes for a company customer interface. So all the rest are resolved through AI. So that possibility is there. But one advantage in mediation is because we are delegalizing the conflict and we are trying to humanize the conflict element. The human element of conflict is being addressed here. I think human mediators may have a big role to play for a very long time, even if AI comes into this field. So definitely, you would prefer to, be heard empathetically, listened empathetically by a human being rather than by a chatbot. Any other questions?
Yes, so we have another question that it is by an advocate.
Hmm.
Sure, sir, she's asking, after getting accreditation in mediation, some institution ask for the number of cases dealt by us. What proof needs to be provided and in what manner?
Can you just come again? What is the question?
The question is, after getting accreditation in mediation, some
Hmm.
institutions ask for the number of cases dealt by us. What proof needs to be provided and in what manner?
That is, a very existential question. The chicken came first or the egg came first? How do you get your experience without actually being able to, without being empaneled and without being able to do mediations? Okay. So I think that institutions should change their, yardsticks for engaging mediators. I think young people should be given more opportunities to do mediations. Maybe they can, co-mediate with some seasoned mediators to get the experience, or maybe they can be used to assist in the mediation process by, being as acting as mediation managers. So opportunities should be created for young people who aspire to become mediators, because only with that kind of experience they'll be able to do mediation. See, today what is happening in arbitrations? Young people are hardly getting an opportunity to be arbitrators simply because everybody wants some gray hair to be seen over there and some experience under the hat. Now, where do you go for that kind of experience unless you get the opportunity? So there has to be some mechanism we need to evolve where we are able to give opportunity to young people to be able to do mediations, or at least get an exposure to the mediation practice, engage in the mediation in such a way that they not only learn, but they also earn something out of that. So that is the only way we can develop the mediation practice and make it into a full-fledged profession. Because if you keep, the moment you finish the training and you see, if supposing I'm conducting a training through my institution, I need to be able to empanel. So the only thing I do is I have an assessment done. Okay, so if you get through the assessment, I empanel you and I give you an opportunity to do maybe small claims first. Okay, maybe matters that are not too big, but then you get the experience, and then we give you an opportunity to work with other mediators, seasoned mediators, so that you learn how to do it, or to even act as mediation managers in mediations where you, subject to you agreeing to maintain the confidentiality, you get involved in assisting the mediators. So we have something like tribunal secretaries for arbitration. So something similar to that. We are trying to work on that, and I think other institutions should also do that. And I don't agree with this thing that you need to have 10 years or 15 years of experience to be a mediator, or to be a mediator. Where do you get that 10 years experience, and why should you, after getting trained and qualified, why should you wait for 10 years? So you should be able to do it, but you should be able to start. You can't expect the sky. You can't expect a multi-crore dispute to be referred to you for mediation. You can't expect a very complex, complicated issue to be referred to you for mediation. You need to learn the work. So that opportunity should definitely be given. And that, we have to create that opportunity. We have to work. See, let us understand one thing. So long we have been having only court annexed mediation. It is only now that institutional mediation, private mediation is coming into force. So it's a work in progress. So we can't be in a hurry. We have to slowly, and we have to all collaborate with each other, because we cannot perceive each other as competitors. No, somebody asked me whether I can come and do a session for another institution, and I said yes, I will come. And they said, "Aren't you our competitor? And how can you come?" I said, I don't believe in competition. We are all collaborators. We need to work together, right? And mediation is all about collaboration and how do you compete with each other in developing the field. The more you develop the field, the more work you get, right? The more the number of institutions, the more the popularity of mediation. And ultimately, it's the quality of service that you render that is going to count, right? People will recognize you by the quality of your service. So we have to create that opportunity. And unless we create that opportunity, how will we attract young people to come into the profession?
Greatly answered, sir. Another question is, do you think the proactive role of advocates will help in efficacious participation and integrity of institutions?
Absolutely. I agree with that. I just saw that question posted by my friend Umar Ahmadan. She herself
Yes,
is
sir.
she's a very well-known and experienced trainer and mediator. So absolutely right, because see, advocates are the biggest stakeholders in dispute resolution. Now, unfortunately, the legal curriculum, the kind of training that we have been receiving so far, is only teaching us the adversarial method of dispute resolution, where we are more problem inflamers than problem solvers. Today, in fact, the Telangana High Court had organized a community mediation training program, and I was invited. And the Honorable Acting Chief Justice of Telangana said that there was a matrimonial dispute between a husband and wife, and each one of them went to the lawyer, and they, because they trusted the lawyers, they signed the petitions. And later on, they realized that allegations of adultery have been included in the applications. And they were shocked when they came to know about that. Okay, unfortunately, that was referred to mediation and it got resolved and they got back together. So, lawyers have a very important role to play in mediation because they are the ones who are going to be guiding the clients. Okay, and lawyers owe a duty to their clients to help them to find solutions, not to get judgments. Okay, there is a difference between treating a problem as something which is right or wrong or reward or punishment, but instead to solve the problem of the client. And most of these are problems of misunderstandings, problems of miscommunication, problems of people not knowing what is really good for them. So lawyers play a very, very important role in this, and lawyers have to, start seeing themselves as problem solvers and not as problem inflamers. They should not think that justice can only be done by the courts. Justice can be done by the parties to themselves by solving the problem. So this whole perception, this whole concept of what is justice delivery needs to undergo a transformation, and we need to, transform our legal curriculum itself to train lawyers in better communication skills, in better negotiation skills, in better mediation skills, so that even if they don't act as mediators, they can act as effective mediation advocates who can facilitate resolution through their clients, for their clients. And that is where I think even institutions can offer that kind of training for lawyers. Since the legal curriculum doesn't facilitate that, we are offering mediation advocacy trainings for lawyers so that they understand how to participate in a mediation. Because you can't go to a mediation process and argue like how you would argue in the court on rights and wrongs. Okay.
Sir, another question is, can you suggest a few firms in India that is leading in mediation practice?
Well, there are so many. In Chennai, we have FCDR. In Bangalore, we have CAMP. We have BIMAC. Then in Delhi, we have Madhyam. In Bombay, we have AMP. In Hyderabad, we have IAMC. Uh, there are so many institutions. I mean, you have to just do a Google search of that and try to find out which is in your city, and maybe reach out to even those who are outside the city, and try to get the best training that you can, and ensure that there are some institutions that offer really quality training. FCDR is doing an ongoing webinar series on what should be the training curriculum. So, which is very important because we need to evolve the training curriculum, a proper curriculum for that. We are also working on it. So, what we need to do is see how we can work with each other. Because instead of each one of us working in our own separate pockets, if we can coordinate and work together to, bring about a transformation in the whole dispute resolution scene in India, it's not going to work out. Okay, we can't work in silos and think that we are going to be successful. That is where the cooperation and collaboration is required between all these institutions. We cannot we cannot treat each other as competitors. We should treat each other as collaborators.
So because as even me being a law student, we face a lot of problem because we have that interest towards mediation and arbitration,
Yeah.
but we face a lot of problem to get internships in this field. So, sir, how do we get exposure here?
See, there are arbitration, getting internship and arbitration should not be much of a problem because there are many law firms that specialize in arbitrations. So their dispute resolution sections have arbitration, verticals where you can perhaps try to get the internship. So mediation, there are few institutions which are of really good quality. Some of the names that I mentioned, and you can perhaps try to get the internship there. And we in IMC we offer internship to students, both in arbitration and in mediation. So but there is a huge demand, so we are able to absorb only three interns at a time, two or three interns at a time. So we keep following that. So we entertain the applications, we review the applications, and then we appoint interns. So we take
Uh,
internship periods of 2 months, 3 months, like that. Yeah.
all right, sir. Also, we have another question from a participant. What lessons can be learned from countries with well-developed mediation frameworks?
Well, the most important lesson that we need to learn from them is that mediation works.
Mm,
Okay, so we need to emulate them, we need to follow suit,
mm,
we need to really seriously focus on that and not treat mediation as some ad hoc process where you just make two parties sit. First of
mm,
all, the courts have taken mediation seriously. Okay, so courts have promoted mediation, but at one point of time, I think should be a laissez-faire that should be applied, where courts should start trusting institutions and allow collaborate with private institutions that are able to offer the kind of quality service. So the courts can look at institutions that are offering quality service and engage with those institutions and even maybe outsource the cases to them, outsource the training to them. Because why should the court take up the whole responsibility of? Because it's a burden on the court. See, you're trying to already fight a huge backlog of cases. So once you promote good institutions to come up and you collaborate with these institutions, you will be able to outsource this work to them and ensure that the growth of mediation takes place parallelly and on a track that could be sustainable. So sustainability is what is important, and we have to keep these goals in mind and work towards having a sustainable mediation practice that service that we can offer.
So we have another question.
Yeah.
As the Mediation Act has not been regularized,
Hmm.
will the mediation settlement agreement be binding on parties?
See, today what we are doing now is because the Mediation Act has not been notified, not regularized, it has not been notified. The law has been passed, but it is yet to be notified. The Mediation Council is yet to be constituted. For some reason that is getting delayed, I don't know why. But until then, what we do is because see, the Mediation Act is repealing the Part 3 of the Arbitration Conciliation Act. But as of now, Part 3 of the Arbitration Conciliation Act exists on the statute book. So what we do is we treat the mediation, a private mediation or a pre-litigation mediation, as a conciliation. And what happens is when the parties reach an agreement, the conciliator authenticates the agreement and it is stamped like an arbitral award. So it becomes an arbitral award on agreed terms. So therefore executable. Okay, so that is the mechanism that we are using for the time being. Of course, under the Commercial Courts Act, pre-litigation mediation, if you reach a settlement, because you have to go for mandatory pre-litigation mediation. If you reach a settlement, it is deemed to be an award under Section 12A of the Arbitration Conciliation Act. And there are other provisions also, like Legal Services Authorities Act is there, but then
Mm,
the more effective method to do is to follow the Arbitration Conciliation Act Part 3. So until the Mediation Act gets notified, that is one mechanism that we can effectively use for implementing mediated settlement agreements.
right, sir.
One
So
thing
we
I
have
just want
another.
to sorry to interrupt you. One thing I
Sure,
want
sir.
to just point out here is that
Yes.
see, normally if you do a mediation effectively and parties voluntarily
Mm,
reach an agreement knowing all the pros and cons, and after you have tested the practical enforceability of the agreement, whether the parties can really perform or abide by the terms that they're agreeing to. The question of enforceability may not arise because parties normally it's their agreement and they are reaching the agreement after deciding that this is the best for them. That is where mediators should not be in a hurry to bring about a settlement. They should engage with the parties and ensure that it is an agreement that is reached after evaluating all the pros and cons, after understanding that this is the best option for them. So in that case, what happens is the question of executability or whether it should be treated like a decree, whether it should be treated like an award doesn't arise. People honor their agreements, okay, because they have entered into it after analyzing everything, after realizing that this is the best way for them. So that problem should not come in a mediation, but if it comes, we have these options until the Mediation Act comes into force.
Okay, so we have another question that says some of the judges do mediation themselves at the chambers. Isn't this give impression that they don't trust mediation process being done by official mediator?
Well, I don't want to comment on that, but there is it only reflects a lack of understanding of how the mediation process works. Because one of the things in a mediation is parties feeling free enough to decide on their own, respecting their autonomy. Now, when I'm sitting as a judge and I'm telling the parties that, like, look, why don't you do this? Now, parties will feel obligated to listen to me simply because I have the authority of a judge. As a matter of fact, we have been advocating that sitting judges should not even act as mediators in matters that are not by them for them also. Because the very fact that you're a judge, the very authority of your post might induce parties to reach an agreement. Because they may feel, they may feel in awe of your presence. They may feel obligated that, they will feel that if they don't listen to you, something bad might happen to them. So that is something that, should not be there. So if the judges are doing that, they're not doing mediation. So let's not call it mediation. They're only trying to bring about a resolution to the dispute and helping the parties to come to some understanding. So I would not only like to call it as mediation, but I would say that judges have every right to do so if they sit in the chambers and if they feel that a matter can be, if they talk to the parties, perhaps parties may reach an agreement or, resolve the matter. You cannot stop a judge from doing that. A judge has every right to do it. It's well within their powers to do it. But don't call it mediation is what I'm saying. And don't call it a mediated settlement agreement simply because it is not a mediation. You're simply advising the parties. Parties are following your advice and they're abiding by it. They are signing an agreement. And you're passing an order based on whatever they agree upon. Okay. So that is not mediation as such.
Sorry, sir. So we have another question that says, can arbitrators act as mediators too, or vice versa?
They can't. Because either you are a mediator in a dispute or you are an arbitrator. Because the law itself prohibits that. Even under the Arbitration Conciliation Act, conciliator cannot act as arbitrator. And even under the Mediation Act, there is a very specific prohibition on that. Because once you are an arbitrator, you cannot be a mediator. Or if you are a mediator, you cannot be an arbitrator.
Arbitrator.
Yeah, because the roles are completely different. Okay, and you may be getting a lot of confidential information that might create a bias in your mind or may affect your neutrality. So therefore, when you sit as an arbitrator, the party should also have the confidence because if an arbitrator sits as a mediator and there is a possibility that if the mediation fails, it's going to go back to the same arbitrator, how will the parties discuss any confidential information? Because they'll feel scared to do that, right? Because it may compromise their interests later on. So it's not fair on the parties also.
All right. Thank you, sir. Seeing no further questions, we move towards concluding today's webinar. I would like to express a sincere gratitude to Mr. A.J. Jawad for sharing his extensive knowledge and experience with us. Sir, your perspectives have provided valuable insights into effective dispute resolution through mediation. A special thanks to all the participants for their active engagement and thoughtful questions, which have enriched our discussion. Your presence and contributions have made this event a success. Thank you all once again, and we look forward to your participation in future events. Thank you all so much.
Thank you. Thank you very much, everyone, for joining today and being a part of this. Wish you all the best.